Good morning once again. You're most welcome on this webinar, The Leaders Talk Africa. I believe for most of us, it's not the first time that we're attending it, but for those of us, if it's your first time, please look out for each of these webinars on a monthly basis. Once again, I'm Hilda Achiro. I work with the Civic Advisory Hub, and I'm happy to moderate this session today. I can see in a chat room, we have people from South Africa. Good morning, Anne Brown. We have Botswana. We have Mozambique. We have South Sudan. We have Zambia. We have a combination of both NGOs, the financial intelligence authorities, and the NGO regulators. We have Uganda. Yes, it's good to see you log into that call. We have Nigeria joining us, Zimbabwe, Mauritius. Wow, that is good. So thank you very much for joining this call. This is the Leaders Talk Africa. This session is dedicated to putting guidance into practice, addressing the unintended consequences attended to FATF Recommendation 8. And on call this morning, we'll have our panelists who are from the FATF-Style regional bodies and the representative of the NGO. On call, we have Mr. Emil Medi, who is coming from Giaba. Mr. Emil Medi is the Senior Research and Documentation Officer with Giaba. We're happy to have you on call, Medi, and we can't wait to learn more about what Giaba is doing, how it's putting this into practice, since the FATF Recommendation 8 was amended and edited and revised in 2023. And then on call, we have our very own, where we belong, Uganda, Eastern Southern Africa Anti-Money Laundering Group, Mr. Mulkenyiga. You're most welcome on this call. And with the Eastern Southern African, as you see when I was reading, there were so many people from the Southern Africa and East Africa. We are looking forward to share insights, and we're looking forward to see how SMLAG, the progress SMLAG has made since 2023 in putting this into practice. And we are also joined by Mr. Yona Wanjala, who is the team leader at the Civic Advisory Hub. Mr. Yona has been part of this drive for over 5 years. So we are also grateful to have you on this call, and we're looking forward to your insights on the progress that has been made on Recommendation 8 since 2023 when it was revised. I'll take this opportunity to invite my colleague, Julie Butinde, our Research and Communication Director, to give us welcome remarks. You're most welcome, Julie.
Thank you so much, Hilda. Thank you. Good morning, good afternoon, good evening, wherever you're joining us from. Thank you for joining another edition of the Leaders Talk Africa. We are always so happy to see such a great and robust turnout for our webinars, people from all the countries that Hilda has mentioned. Just to kick off our session today, our topic is putting guidance into practice, addressing the unintended consequences attendant to FATF Recommendation 8. So now, as you may or may not know, FATF Recommendation 8 that is intended to protect NPOs from terrorist financing has been some misapplication of this standard, and there have been unintended consequences experienced by NPOs, including bank de-risking, some burdensome compliance demands because of the blanket application of the standard. And then in some jurisdictions, there have been reports of the standard being used to justify targeting of NPOs. So recognizing this, FATF revised the standard in 2003, and the revised standard now emphasizes that not all NPOs are actually, that this standard doesn't apply to all the NPOs except those that are under the FATF definition of NPOs. It also promotes the use of risk-based approach to monitoring. So today, our goal is very simple. We want to investigate the progress. First of all, we also want to investigate that there are some unintended consequences that remain after the revision of the standard, and where we can, but most importantly, where we can, as NPOs and FSRBs, we have SMLAG and GIABA on, where we can, where do we play, what role do we play in ensuring that the revision, the revised standard is actually being applied as intended. So those are my few opening remarks just to set the tone. I wish all of us great deliberations. Thank you once again for joining us, and I hand over back to Hilda to guide the rest of the session. Thank you.
Thank you very much, Julie. Thank you for setting the tone for the webinar, and thank you very much for taking us through what this webinar is actually focusing on. And we are very, very hopeful that by the end of this 1.5 hours, we'll have, as participants in the call, we'll have a clear understanding on the unintended consequences that are still affecting the NPOs within the Eastern Southern Africa, the Western Africa, but also Africa at large, because our problems are usually interlinked. It's so rare to find that the problems that the NPOs in East Africa, that NPOs in East Africa are facing are different from the problems that NPOs in West Africa or MENAT FATF region are facing. So this, at the end of the call, we hope that we'll have a clear understanding. We hope that we'll get clear insight on how the FSRBs are translating this revised Recommendation 8 with the best practice paper that was released alongside it across the jurisdictions that are subscribed to them. I'll take this opportunity to welcome our first panelist, Mr. Emil Medi from GIABA. Mr. Emil Medi, like I told you before, he's the Senior Research and Documentation Officer with the Intergovernmental Action Group Against Money Laundering in West Africa, which is GIABA. GIABA is a regional body against money laundering, terrorist financing, and proliferation of financing. And he will tell us, Medi, you're most welcome on call. And what I would like to know from you is, many GIABA member states are navigating FATF grey listing and active counterterrorism operations. How has GIABA how is GIABA helping member states reconcile the security imperative and navigating the grey list-induced panic without disrupting the legitimate NPOs activities, the operation? And then also, what technical assistance, guidance, or peer learning has GIABA rolled out to its member states since the revision of Recommendation 8, particularly on the conducting of proper NPO sector risk assessments and where the biggest implementation gaps remain? And before Mr. Emil comes on, I will encourage the participants to use the chat list and the Q&A. We will have a Q&A session after the panel discussion. So we'll allow other people to speak. But in the meantime, if you don't want your question to evaporate during the presentations, please type them in the chat room. We are going to retrieve them and the panelists will respond to them. If you can note them down in your notebook, please do so. And then after the presentations of all the three panelists, you'll raise up your hand and we'll pick you and you'll ask your question. Over to you, Mr. Mel-Eddy. The floor is yours.
Yeah, thank you, Hilda. And good morning, good afternoon, and good evening to everyone, depending on the part of the globe you find yourself. First of all, let me thank the Executive Director of the Civic Advisory Hub, Mr. Yonawanjala, and your entire dedicated team, and also my distinguished co-panelists from SMLAC, Mr. Molek Yega, all esteemed participants, for inviting me here. Let me quickly say that Yona and Molekin are my brothers. We've been brothers for so long. And I know they have also been deeply involved and has actually played significant roles over the years when it comes to this subject matter. So yes, I would move straight to the points. As you said, indeed, I am here to share GIABA's perspective on how countries can effectively balance the imperatives of national security and counterterrorism efforts, while also ensuring that they are avoiding what has increasingly been described as the grey list-induced panic, particularly in the implementation of the FATF Recommendation 8 without disrupting legitimate NPOs. I would want to say that primarily, everybody acknowledges the fact that NPOs play a critical role when it comes to humanitarian services globally. So the role of NPOs cannot be diminished. It's a well-known, well-accepted fact. They play so much roles that sometimes even the central government itself is unable to provide. And that is why even we are the FSRB, the FATF, and all stakeholders involved in this conversation will always want to highlight the fact that the NPOs are partners to the socioeconomic development of our countries. Now, first of all, permit me to provide a brief overview of the regional context and explain why this issue is particularly important, not only within the Jaba region, but also across other regions facing similar challenges. Begin with West Africa, and indeed the Jaba region continues to face significant terrorism and terrorist financing threats. Several terrorist groups, including the Jenin, Islamic State West Africa Province, Boko Haram, and other affiliated groups remain active within the region. In fact, according to the 2025 Global Terrorism Index, the Sahel, which encompasses a number of our member states, continues to be regarded as the global epicenter of terrorism, accounting for a significant proportion of terrorism-related deaths and incidents worldwide. So you understand why many countries, in their genuine efforts to address these security and terrorist financing concerns, often adopt measures targeting the NPO sector, which available evidence has shown that some of them can be vulnerable to abuse, and indeed some of them being used to facilitate the activities of these terrorist groups. However, in the absence of a properly calibrated risk-based approach, some of these measures inadvertently create challenges for legitimate NPO activities and undermine the very objectives that they seek to achieve. As for the challenges, we all know some of them are still persisting. Others have reduced in terms of their impacts. We have overregulation of the NPO sector, excessive registration and licensing requirements, restricted access to financial services, delays in accessing and transferring funds, and all that, excessive reporting and compliance burdens. So these unintended consequences, some of them are still prevailing, but I'll admit that over the years, frantic efforts, which I'll be talking about very soon, have been made to ensure that these unintended consequences, if not eradicated, are minimized. And indeed, we are working with all member states to ensure that we actually phase it out of the system. So that is a security situation of the West African sub-region, not unique to us, but within the context of Jaba member states. Now, I'm saying this because it is important for us to appreciate why some of these countries are implementing these measures. Now, before I proceed, Hilda, how many minutes do I have, please?
You have 10 minutes. You speak up 11:30.
Okay, that's fine. So let me time myself, but if I'm going beyond my time, please feel free to draw my attention. Now, secondly, if you look at the result of the second round of mutual evaluations of Jaba member states, it reveals significant weaknesses in the implementation of the FATF Recommendation 8. Many member states made progress in strengthening their technical compliance. However, when it comes to Recommendation 8, which is on the NPO, a lot of countries were still lacking. Indeed, as at the mutual evaluation, 17 Jaba member states were assessed, and 12 countries representing approximately 71% were rated non-compliant with Recommendation 8, while the remaining 5 were rated partially compliant. So these, among other things, led to some of these countries being put on the FATF grey list, or what we call the jurisdictions under increased monitoring, but popularly called the FATF grey list. Of course, not only the NPO concerns, but other concerns largely on effectiveness of the entire AML-CFT regime. But the NPO concern is a very strategic one, and you could understand, because if you look at all the action plans that have been drafted for all these countries that were placed on the FATF grey list, NPO featured. NPO sector was a major concern, and it featured in all the action plans of these countries. So, coupled with the security circumstances and the grey listing process, which inevitably creates considerable pressure on countries to demonstrate progress and tangible results, you see countries in a rush to take actions in order to implement the measures and get off the grey list. Now, this pressure sometimes results, and in a lot of situations, resulted in what has increasingly been described as the grey list-induced panic, where countries, in their effort to demonstrate swift action, adopt measures that may be broader or more restrictive than necessary. In some cases, this has led to regulatory approaches that inadvertently affected a wider NPO sector, including legitimate humanitarian, charitable, and development organizations that pose little or no terrorist financing risks. So this challenge is particularly relevant for jurisdictions on the FATF grey list. Yes, and I've already mentioned all of them: Ghana, Senegal, Nigeria, Burkina Faso, Mali. They all had NPO-related action items as part of the ICRG action plan. Now, the key challenge, therefore, has been ensuring that efforts to address these deficiencies, including the security challenges, remain targeted, proportionate, and risk-based, consistent with the letter and spirit of the FATF Recommendation 8. This brings us to the critical question: what does the FATF Recommendation 8 actually require of countries? And why is it that despite the revisions and guidance, many jurisdictions continue to struggle with its effective implementation? Or maybe, let me put it differently. Why do we still see instances where Recommendation 8 is implemented in a manner that extends beyond its intended scope, and sometimes leading to these unintended consequences that I've already mentioned? Now, this question is critical to our discussion today because many of the implementation challenges you observe across jurisdictions stem not from the standard itself. And I want to say that again. Many of the challenges we observe across jurisdictions stem not from the standard itself per se, because as we've heard, it has gone through revisions, guidance notes have been published to explain the requirements and all that. So largely, it has been from misinterpretation and misunderstanding of the requirements of FATF Recommendation 8. Now, the requirements is largely sequenced in 3 steps. 1, we are expected to identify which subset of organizations fall within the FATF definition of NPOs, which means that some will not fall within the FATF definition. Then, those that fall within the FATF definition, we are expected to conduct a risk assessment of these NPOs to identify the nature of TF risk posed to them. And once we've been able to identify and assess the TF risk exposure, we can then put in place focused, proportionate, and risk-based measures to address the risks identified. Of course, other regulatory measures, targeted measures are in there that countries are expected to implement. Now, in all this, all the risk-based targeted measures to be implemented in addressing the identified risks must be without unduly disrupting or discouraging legitimate NPO activities, which we all know. The methodology itself is unambiguous and imposes a mandatory procedural requirement, which sometimes the lawyers will say procedural limitations when it comes to constitutional law, on countries, and this obligation is not discretionary in nature. it is a must for you to conduct the risk assessment. First of all, it's a must for you to identify the subset that falls within the FATF definition. It is a must for you to conduct the risk assessment, and it is a must for you to take those focused, proportionate, risk-based measures. So it is without discretion, really. But this requirement itself serves as an important safeguard and effectively constrains state action by ensuring that measures adopted are guided by defined risk-based principles rather than broad and arbitrary approaches. I'll quickly move to what JABA has been doing to help countries to ensure that the implementation of Recommendation 8 is done within the letter and spirit of what the requirement expects of us. Distinguished participants, ladies and gentlemen, now having outlined some of these key challenges, it is important for us to know that the FSRBs are also there to assist member states to address all these challenges. In fact, what we have seen across our member states is that as at the second round of mutual evaluation, most of them have not conducted NPO risk assessments. That is one. In fact, some of them had actually classified NPOs as DNFBPs or reporting entities, and therefore subjecting them to the entire AML-CFT preventive measures, such as customer due diligence, submission of suspicious transaction reports, record-keeping obligations, and all that, which is not what the standard required. Those who also had some form of risk assessment, it wasn't well done. And what they ended up doing, especially those who had a lot of terrorism, active terrorism groups operating within their jurisdiction, ended up classifying the entire NPO sector as high risk, which again is not what the requirements expect us to do. So taking lessons from that, it's important the FSRBs assist our member state to ensure that they are implementing it rightly. So broadly speaking, our intervention, I can group into our 6 thematic areas aimed at promoting a risk-based, proportionate, and effective implementation of the standard. 1, policy guidance. So following the revision of Recommendation 8, we issued policy guidance sessions for member states outlining the key changes to the standard and clarifying its requirements with a view to supporting consistent, effective, and risk-based implementation across the region. 2, conduct of regional typologies. JABA has undertaken a series of regional typology studies on terrorism financing and related threats within member states, many of which have highlighted practical examples of how NPOs can be abused or misused for terrorism financing purposes. These studies are intended not only to enhance understanding of emerging risks and typologies, but also to support member states in conducting more informed and evidence-based NPO sector risk assessment and implementing targeted risk-based measures as expected. 3, technical assistance. JABA continues to provide financial and technical assistance to member states in conducting and updating their national MLTF-PF risk assessment, of which the NPO sector risk assessment form an important component. This support includes sensitization and capacity building on the use of recognized risk assessment methodologies, particularly the World Bank Risk Assessment Tool, which countries are free to adopt and or adapt to their national context. The objective of this assistance is not for JABA to conduct the assessment on behalf of the countries, as this would compromise our role as an assessment body, but rather it is to strengthen national capacity to undertake credible evidence-based risk assessment. Countries would have to take ownership of the risk assessment process. And I would say all countries benefited from this. So as we speak, all countries have now conducted or are conducting their NPO risk assessment, even as we proceed into the 3rd round of mutual evaluation. Peer learning and regional dialogue. We also continue to promote peer learning and knowledge sharing through regional workshops, experience sharing among member states, and dissemination of lessons learned from mutual evaluations. For example, over the years, and indeed last year, 2025, we organized a regional virtual sharing session on effective implementation of Recommendation 8. Additionally, an entire session of the RTMG PRG meeting, so the statutory plenary meeting, an entire session of the November statutory plenary meeting was dedicated to capacity building on Recommendation 8. And with financial support from GIZ, for example, representatives of NPO regulatory bodies from all member states were fully sponsored to participate physically in the session, which was facilitated by internationally recognized experts on Recommendation 8 engaged through the GIZ program. And we continue to have these conversations even in our public-private sector consultative forums and other regional engagements, just to promote an understanding and knowledge sharing of what is expected of us. And let me quickly take this opportunity to mention that JABA, also in collaboration with SAMLAC, will be organizing a master class on assessing compliance with FATF Recommendation 8 during the High-Level Africa Civil Society AML-CFT conference scheduled for Abuja in July 2026. So those who will be there will be glad to have you. Now, the fifth area under which we support member states.
2 more minutes. Sorry for interrupting you. Two more minutes.
That's fine. The fifth area has to do with the mutual evaluation process itself and its follow-up process. So yes, we are an assessment body. We conduct the mutual evaluations using the FATF methodology, and it means that we are assessing countries based on the Rec 8 and IO10 related issues. We evaluate them as to how they are implementing Recommendation 8 without disrupting legitimate NPO activity. And of course, this report comes with recommendations, and then we assist them through the follow-up process to ensure, we monitor them through the follow-up process to ensure that they implement these recommendations to avoid these unintended consequences. Then lastly, we also have, as part of our process and procedures, provisions targeted at addressing unintended consequences issues raised by member states at any time. So at least any 2 or more member states or parties consistent with the FATF process, any 2 or more parties that raise issues regarding to unintended consequences of any of our member states, the process is activated to ensure that there is engagement in order to address it. In fact, as we speak, we have one of our member states which have been cited for implementing measures resulting in unintended consequences for which appropriate action is being taken. So let me conclude by saying that quickly that when it comes to implementation of Recommendation 8, it is about collective effort. It is about engagement. It's about ensuring that the NPOs themselves are involved deeply in the risk assessment process. It is about ensuring that you are moving along the value chain with all the stakeholders so that there is a common understanding of how it is expected to be done. And I'm happy to say that as we speak, if you take the JABA member state, during the mutual evaluation, 71% were rated non-compliant, but as we speak, it has reduced to 47%, with one country, Nigeria, for example, rated fully compliant, and 2 other countries rated largely compliant. We expect that this would improve going into the 3rd round. So largely in conclusion, yes, this is how JABA has been assisting our member states. And we always tell them, every country that is implementing FATF Recommendation 8 to the detriment of the NPO sector is doing itself a lot of damage, because that is not what the recommendation expects. Rather, we must see the NPOs as partners of development. We need to work together with them, even as we address our security concerns, even as we address our deficiencies. It is important we ensure that we are creating the enabling environment for them to flourish to the betterment of our people. So on this note, I thank you so much for your attention, and sorry for going a bit above the allocated time. Thank you.
Thank you very much, Emil. It was expected. But before we proceed, where do we still have some biggest gap in implementing Recommendation 8 in the West Africa? If yes, what are they? Could you just highlight a few in 2 minutes?
Yes, we do. We do still have some gaps. Largely, the gaps goes around overregulation. Because as I said, a lot of countries still, in their bid to address the security concerns, are overregulating. In fact, they are putting in place a lot of requirements that is not intended under the FATF recommendation. So we are working with them to ensure that that is addressed. We've also had reports of NPOs sectors having challenges with transferring funds because, for example, one of our member states, I think they passed a legislation or a directive requiring all NPOs to have a bank account at a particular entity and all that, which is not actually what is intended because all these things must be targeted. And so these are some of the unintended consequences still persisting. But I would say again that if you look at from the last 5 years and all that, or since the revision of the FATF Recommendation 8, I think we have made tremendous efforts. A lot of countries are now appreciating and are having a better understanding of the requirement. And so all these unintended consequences are coming down. Of course, there is still more room for improvement. We hope to ensure that it is fully addressed as we move on. Yeah, thank you.
Thank you very much, Emil. Overregulation and has been a persistent problem over the years, and the challenges of transferring funds has also now become increasingly a challenging factor across the continent, with different countries bringing about laws that need to closely monitor the funds that NPOs bring in the country. I appreciate the fact that you recognize that NPOs are partners in social and economic development in Africa. And this is something that FATF also does. And in your presentation, you also highlighted that Giaba region, you continue to face the terrorism threats. And with the likes of Boko Haram still actively very terrorizing people, and also other groups that are in the region. But I like the fact that you bring it out that we need a collective effort to implementing Recommendation 8. And this is something that resonates with what Civic Advisory Hub does. Civic Advisory Hub believes in collective effort of bringing the private sector, bringing the state, bringing the FSRBs, bringing in the NGOs to address these unintended consequences. So thank you very much. Thank you for highlighting how you are supporting the member states in policy guidelines, conducting research on regional typologies, and I would urge members of the civil society to look out for some of these typologies that have been published, because you mentioned that they have practical examples of how NPOs can be abused and how they're still vulnerable to terrorism abuse. And it has some of the practical recommendations, something that we can take in as members of the civil society. So thank you very much. I'll take this opportunity to welcome our next speaker from the SMLAG, Mr. Mulken, Senior Legal Expert with SMLAG. SMLAG is a regional body that Uganda, the country that seated in, subscribes to. So it's basically subscribing to the global standards to combat money laundering and financing of terrorism and proliferation. Mulken, since October 2023, revision of Recommendation 8 and the updated best practice paper, what concrete steps has SMLAG taken to support member states in moving from a blanket approach to risk-based, proportionate monitoring? SMLAG is actively conducting mutual evaluations of its member states. What is SMLAG doing differently in this round to assess whether national measures on NPOs are proportionate and focused only on high-risk NPOs? And how are civil society perspectives and evidence being incorporated to these evaluations? You'll be speaking up to 11, up to midday, 20 minutes. I hope that's sufficient.
Indeed, sufficient, Hilda. Thank you so much. First of all, I would like to appreciate the Civic Hub Advisory Hub to invite me to be part of this important event. NPO matters are also important for the SMLAG region, like my colleague Emil has alluded to. First, I think let me thank the Civic Advisory Hub, like I said, to organize this event. And it is also great to see all of you to be part of this engagement, and hopefully it will continue until such time that we capacitate all African countries in the continent towards the point of applying risk-based approach on the effective implementation of the FATF Recommendation 8, which talks about non-profit organizations. Now, since FATF revised the methodology in February 2024, and since the issuance of the November 2023 updated best practice paper, ISAMLAG noted it as an important shift in the global understanding of how countries should approach the non-profit organizations. These standards, we believe, they also support our principles that we are consistently supporting, envisaging how NPOs are important for our member jurisdictions when it comes to the issue of development, doing the good work in general, and at the same time also respecting, fulfilling human rights, especially the freedom of association, by having good number of our NPOs, good number of NPOs in our region. At the same time, we need to act on terrorism financing. As my brother Emil alluded to, ISAMLAG is also facing some terrorism and terrorism financing related risks. Recently, we were conducting a regional terrorism financing risk assessment. We found active terrorist groups at national, regional, international level. I can mention the four of them, which are really a concern at regional level, like the Al-Shabaab, the ISIL Somalia, ADF or ISCAP, what we call, and ISIL Mozambique. All these terrorist groups, they are still active, albeit at different level in our region. And according to our study, we realize that some of these terrorist groups, they are having attachment with global terrorists like Al-Qaeda and ISIL. And they are one of the techniques for them to raise, move, and use funds is by abusing the non-profit organizations. We identify the type of different non-profit organizations which might be susceptible for terrorism financing risks. So we need to balance between human rights, the role of NPOs on one hand, and how to also counter terrorism, because NPOs, in our view, they can also play in the fight against terrorism, terrorism financing, and other financial crimes. So as ISAMLAG, we are encouraging our members to regulate NPOs by applying a risk-based approach, but without disrupting or discouraging the legitimate charitable and humanitarian activities. And this issue is important in the ISAMLAG region. Our region has a vibrant and diverse civil society sector, which we note. NPOs, when they are delivering humanitarian assistance, health services, education, peace building, community support across areas affected by poverty, conflict, displacement, and climate-related crisis, they are playing, a big role, like I said before. And in many of our member states, the NPOs fill critical gaps that government alone cannot address. So to balance between the issue of countering terrorism financing and keeping also the interest of NPOs in good shape in order not to disrupt their legitimate activities, we need to prevent any violent extremism. We need to prevent radicalization. We need to prevent any terrorism-related activities. by misusing NPOs. This means that we need to strike a careful balance. Governments must protect national security without undermining the civic space or restricting legitimate charitable work. Now, to make sure that our member countries are striking the balance between national security and the interest of NPOs, since the February FATF revision, 2024 FATF revision, ISAMLAG has taken several concrete steps to support member states in moving away from blanket approaches and towards more focused and proportionate frameworks. I can mention some of the examples that we normally did. First, ISAMLAG has intensified awareness and technical engagement with member states on the revised FATF standards and the updated best practices paper. We have incorporated the revised Recommendation 8 requirements into regional workshops, assessor training programs, technical assistance discussions. These engagements normally focus on helping countries to understand that not all NPOs are posing or presenting the same level of risk or high risk. The standards also require countries to identify only those subsets of NPOs that are vulnerable to terrorist financing abuse, and this requires evidence-based risk assessment, but not assumptions at all. ISAMLAG has therefore encouraged its member states to review their existing laws. I can mention some of them. For example, you have raised the issue of overregulation. Some of our member countries, they used to list NPOs as one of the reporting institutions, like banks, lawyers, accountants, who are normally establishing a compliance function towards the implementation of anti-money laundering, counterterrorism financing laws. But now, as a result of our engagement with our member countries, many jurisdictions, they have delisted NPOs as one of the reporting institutions, so that it will not be overburden some on their side, or it's not going to subject them under overregulation. We also engage with some private sectors like banks and their supervisory authorities to make sure that when they are dealing with their NPO clients, customers, when they are establishing business relationship with them, they are not going to consider or categorize the risk of NPO's customers as high risk, high for terrorism financing, because this is also bringing unintended consequence like financial exclusion and de-risking. So we started sensitize institutions like banks, their supervisory authorities, to make sure that they are also applying a risk-based approach when they are treating their customers like non-profit organizations. So they need not to apply broad controls to the entire NPO universe without demonstrating risk justification first, especially from a terrorism financing point of view and somehow money laundering. Secondly, ISAMLAG has supported the strengths of different jurisdictions when they are dealing with risk assessments on NPO sector, both from terrorism financing and money laundering point of view. I am saying money laundering because there is a requirement in Recommendation 24, the FATF, which talks about, and also now Recommendation 25, countries to undertake risk assessments from money laundering, terrorism financing point of view on all types of legal persons and arrangements, which also include NPOs. We are also encouraging our countries to undertake sector-specific assessments that consider the nature of NPO activities, source of funding, geographic exposure, delivery channels, and operating environments. We are emphasizing the importance of using concrete evidences and anecdotal evidences, including intelligence, law enforcement information, and engagement with the sector itself, the NPO, by involving themselves in the national risk assessment, as well as, to to provide the necessary information which can serve as an input for them to come up with a comprehensive NPO risk assessment. Importantly, we have also stressed that the absence of evidence of abuse should not automatically lead to a conclusion that an entire NPO universe is at high risk. Thirdly, SAMLAG has promoted dialogue between governments and civil society organizations as part of their private-public sector dialogue. One of the recurring lessons from previous evaluation rounds was that many NPOs did not fully understand terrorist financing risks. Not only terrorist financing risks, but also the concept of terrorism financing itself, while authorities often lacked a detailed underscoring of how the sector operates in practice. This gap sometimes resulted in mistrust and overly restricted measures. So to address this, SAMLAG has encouraged its member states to institutionalize engagement mechanisms with NPOs. We have highlighted the value of consultation during legislative reforms, risk assessments, and policy development. We have also encouraged outreach programs, which is informed by a comprehensive risk assessment that would build awareness without creating fear or unnecessary compliance burdens on NPOs and their donors. As a matter of engaging with the FATF, we would like to share with the participants that we are also members of the global network, and as the members of the global network, we have started implementing the new revisions on the universal procedures in relation to unintended consequences of implementing FATF Recommendation 8. So we have amended our procedure. So if there are any escalations that would have, overly restricting, overly regulating, and so on and so on, we are welcoming the interested parties to approach us to make sure that we are engaging our member countries after determining that there is a prima facie evidence to deal on the matter. And as a SAMLAG, we have also conducted the regional TF risk assessment, like I said, and the NPO matter is covered under that one. And recently, actually, we did a very important project on the horizontal review of FATF Recommendation 8. Our brother, Mr. Yona Wangela, Executive Director of the Civic Advisory Hub, was one of the co-chairs of the project. I would like to appreciate him for the work, the quality work that he has done with the project team. And this horizontal study is going to be published on the SAMLAG website very soon. We are finalizing it to make sure that it is ready for publication. And proportionality in the current round of mutual evaluation. Dear participants, SAMLAG is conducting a new round of mutual evaluation. In this round, we are approaching FATF recommendation specifically 8 differently and with greater focus on effectiveness, proportionality, and evidence. One important change is that assessors are now expected to look beyond the mere existence of laws and regulations. In previous years, countries sometimes focused heavily on technical controls, registration requirements, broad supervisory powers. But the current approach asks a more important question: are the measures targeted to the actual risks identified as a result of risk assessments? Assessors are therefore examining whether countries have properly identified the subset of NPOs that may be vulnerable to terrorist financing abuse. We are looking at whether supervision is directed towards higher risk entities rather than applied uniformly across the entire sector. This means evaluations are assessing issues such as I can mention some of the issues that we are normally raised now during the time of the assessment. We are almost completing the Burundi assessment in this round. Questions such as these ones were raised. For example, whether the risk assessments are evidence-based and periodically updated to make sure that the risk is dynamic and recalibrated, whether outreach and monitoring activities are proportionate to the level of the identified risk, whether sanctions or administrative measures are applied fairly and appropriately, whether a legitimate NPO activity can continue without unnecessary disruption, whether the authorities understand the operational realities of humanitarian and charitable organizations. And another important difference in this round is a stronger emphasis on outcomes and practical implementation. Assessors are considering whether measures are actually mitigating terrorist financing risks while preserving legitimate activities. Excessive restrictions, unnecessary delays in registration, blanket de-risking or indiscriminate freezing measures may indicate that a country has not properly implemented the risk-based approach required under Recommendation 8. ISAMLAG is also encouraging assessors to consider unintended consequences, whether measures result in reduced humanitarian access, barriers to financial services, or shrinking civic space without demonstrating risk justification. These issues are relevant to the assessment of effectiveness and proportionality. And at the same time, we recognize that countries operate in different contexts. Some member states face higher levels of terrorist financing threats than others. The evaluation process will therefore remain context sensitive and evidence driven than the previous round of mutual evaluation. Now, in terms of answering your third question on incorporating civil society perspectives and evidence to ISAMLAG evaluations, the inclusion of civil society perspectives have become increasingly important and part of ISAMLAG evaluation, like I alluded to. We recognize that civil society organizations are not simply subjects of regulation, they are key stakeholders and valuable sources of information. So we involved, like I said, the different civic society organizations, including the Civic Advisory Hub, in our horizontal review study. And in this round, assessors will normally engage directly with representatives from the NPO sector during on-site visits and face-to-face meetings. These discussions will help the assessors to understand how laws and supervisory practices operate in reality. Civic society input can provide critical evidence on issues such as the extent and quality of government engagement with the sector, practical challenges in registration, reporting process, access to banking and financial services, like I indicated before, the impact of counterterrorism financing measures on humanitarian operations, awareness of PF risks within the sector itself, and the degree to which outreach and guidance from authorities is useful and proportionate while we are determining the level of effectiveness and compliance with FATF recommendation and immediate outcome team. ISAMLAG also values evidence from umbrella organizations, humanitarian actors, faith-based organizations, and community-based groups. Different organizations experience regulatory measures differently, and this diversity of perspective strengthens the quality of the evaluations. Importantly, assessors are now encouraged to triangulate information from multiple sources, and as you could see, like my brother Emil indicated, this activity, these efforts, they really require collaborative efforts. And no regulatory authority, no NPO should work in silos. And ISAMLAG also doing the same thing. So it is a triangulation process. And we don't rely solely on official government narratives. We consider legislative frameworks, operational data, supervisory records, private sector feedback, and civil society experiences together. This contributes to more balanced and credible assessments. ISAMLAG further recognizes that meaningful engagement with civil society must continue beyond the evaluation process itself through technical assistance and training. Effective implementation of FATF recommendation depends on trust, transparency, and ongoing dialogue between authorities and non-profit organizations. Countries that sustain these partnerships are generally better positioned to identify genuine risks while preserving the essential roles that NPOs play in society. I think saying this, let me indicate that we remain committed to ensuring that our mutual evaluations reflect practical realities, credible evidence, and balanced judgment. I thank you.
Thank you very much, Mulken. Picking up from where you closed from the evaluation value of practical realities, and I appreciate the fact that you take feedback from civil society. We are one of the beneficiaries who have gotten the opportunities to engage with SMLAG, and here you are again on the TLT Africa platform. We've taken part in the horizontal review study for the Eastern Southern Africa, and which was presented in the last meeting. And we appreciate that. And we hope that more and more members of the civil society get to engage more with SMLAG. Just like the Western Africa, we still have also terrorism groups within the region, and there are quite many. So I think this is an intersecting problem that both regions get to face. And with that, you can't rule out the fact that NPOs can be at the risk of being abused. But I like the fact that SMLAG tries its level best to balance between human rights and countering terrorism financing, something that you've continuously highlighted, and how you urge the countries to do the same, to balance national security and human rights, balance national security and civic space. So you've encouraged countries to move away from blanket laws and to have several engagements. And we are one of the countries which Yona will speak to it, that were NPOs were reporting entities, and my colleague Yona will speak to that. So there is improvement, and there are still gaps, but collectively we work towards that. I'll take this opportunity to welcome Mr. Yona Wanjala, our team leader at Civic Advisory Hub. Yona, you're most welcome. Yona, drawing from the Ugandan perspective, what has actually changed for the NPOs and what has not since the revision of Recommendation 8? Where are you still seeing the same unintended consequences that the revision was meant to curb? The revised Recommendation 8 also recognizes that where NPOs already have adequate self-regulatory and internal control measures in place, national authorities need not impose additional measures. What does it actually take for NPOs to evidence this credibility to regulators and financial institutions, and what practical strategies have worked? Looking ahead to the high-level civil society AML-CFT conference in July in Abuja, what are one of or two priorities that as African civil society should be pressing onto FSRBs, national authorities, and FATF itself to ensure that revised Recommendation 8 translates to a genuinely conducive operating environment for the sector? You're most welcome, Yona. The floor is yours.
Thank you, Hilda,
You have
for
up
the
to
opportunity.
You have 20 minutes, up to 12. You have
Okay,
20 minutes program. Yeah.
Good afternoon, listeners from East Africa, the Pearl of Africa, and good evening from wherever you are seated. Comrade Mulken, thank you for that deep insight. It has simplified my presentation and submission. And my brother Emil, with whom we've worked together again with Mulken, still on the same agenda. Thank you for a very comprehensive insight from West Africa and Giaba. To both of you, send my regards to the Director General, Edwin Harris, then to the ES, my sister, Fikile. To our listeners, thank you again. As Wanjala Yona is my name, like you've had a work with the Civic Advisory Hub as a team leader. and Nasema Habari from East Africa. Hilda, you've given me a mouthful of questions, but hopefully I'll use the 20 minutes or even less to make a presentation in line with the questions. I think the first question is drawing from Uganda. Is there anything that has changed? I should say that yes, in line with countering the financing of terrorism, in line with the normative and institutional framework, significant changes have taken place in the country. As you might be aware of the revision of Recommendation 8 that anchors its implementation on Recommendation 1, that countries should be able to identify those NPOs that fall within the FATF definition. Countries should take an initiative to assess the risk and understand them, then come up with proportionate measures to counter the terrorism financing risk in their respective jurisdiction. In Uganda, Uganda published a report on the National Risk Assessment for TF for the NPO sector 2021-2022. And this particular report highlighted that the risk of TF obtained to the sector is quite low. So the country was supposed to come up with a proportionate measures in line with the recommendation of this report. Ideally, the report in Uganda highlighted that the risk is still high on certain entities like those running madrasas. So what has changed in this? Building on this report of the National Terrorism Financing Risk Assessment, in 2025, I think around 5th of February, the NPOs in Uganda were delisted from the list of accountable persons. For some of you who might have been familiar with the Ugandan ML regime then, the Anti-Money Laundering Act 2013 had listed NGOs as accountable persons, subjecting it or the sector to requirements like those of other financial institutions. The Mutual Evaluation Report of 2016 of SMLAC, paragraph 203, highlighted that this is contrary to the standards of the Financial Action Task Force. The intent was not to list NPOs as accountable person, but to come up with proportionate measures that can counter the risk of terrorism financing. This took long. The recommendations were noted by Uganda as a country, but it took long to delist. However, in line with the question, yes, now there are changes. We are no longer accountable persons. We don't require to go to the Financial Intelligence Authority to get clearance certificate for registration or renewal of our permits. To me, that is an achievement in the right direction. The other change is that, again, through the recommendation, there was a recommendation on targeted outreach. However, the fact remains that little was known about the TF risk amongst the NGO sector. So there are joint initiatives between the NGO sector and the NGO regulators and other subject matter experts to bridge the knowledge gap, to create awareness on what NGOs need to know when it comes to terrorism financing risk. What should they have in place? Simple things like know your employer, know your donor, know your beneficiary are some of the key drives that have been taking place. And I should say, reasonably, there is reasonable level of awareness when it comes to the TF risk. The other component that perhaps, again, through the leadership of Civic Advisory Hub that we've been encouraging is to create meaningful platforms for dialogue, meaningful platforms for feedback on misapplications of the unintended consequences. And this has been done in Uganda under the talk-to-your regulator platforms of engagement, which have also been running in different countries, again, under the leadership of the Civic Advisory Hub. Other countries have given it what I would call the local name. South Sudan calls it Kadewa Nasu, kind of less talk. Botswana calls it a Rebue. Kenya is using Talk to Your Regulator and Zimbabwe. And these have given relevant reforms and feedback when it comes to the misapplication, or rather the mitigation of an unintended consequence, but also cultivating trust between the regulator and the regulated. What are those that perhaps could be missing? One of the things that is key in the missing act, and I'm happy that we're talking to colleagues from the FSRBs, the FATF regional style bodies. I think they would be our ambassadors in their high discussions. What is happening is that the unintended consequences have taken a mutation approach. If you remember the COVID virus, it was mutating, responding to the vaccine. As you are still dealing with COVID-19, there is another variant that would come in, like is it the desert variant and other variants, requiring additional boosts. So equally, the unintended consequences have mutated to yet a different shift. I know in 2021, the Financial Action Task Force launched a study to assess the unintended consequences. A very comprehensive, precise report was written that highlighted aspects of the unintended consequence. These were captured, and this actually informed the amendments in the Recommendation 8, the interpretative note, and the best practice paper. And we also appreciate and acknowledge that the Financial Action Task Force has heavily invested in guiding countries on how best to implement these standards. However, some of the sector players across, including some in Uganda, are asking, are these unintended consequences, or they are actually intended? By the time the bank chooses to de-risk an NPO, is it unintended? Is it an aspect of lack of awareness? Or there are some glooming and looming forces behind such a decision? By the time a regulator takes an approach of suspending the operation of NPOs, is it an unintended consequence, or it's taking a different shift? As you might know, listeners and comrades from Giaba and SMLAG, across Africa, some of the countries are adopting legislations that are not leaning on money laundering or terrorism financing, but they're highly leaning on national security. However, they have implication and restriction on the financing channels and flow in the country. I know the Patriotic Act from the Eastern Southern the Zimbabwe is not news. We just passed a law on the Protection of Sovereignty Act in Uganda. So as who are still dealing with the Anti-Money Laundering Act, counterterrorism, the shift of unintended consequence is taking a different direction. I think if at all it was on sanction, would say they were avoiding sanctions of the implication of unintended consequences. Maybe you need to note that as you are looking at the effectiveness, there is need to broaden the scope of this assessment of effectiveness. Which other legislations beyond those ones on the MLCFT regime of a particular country actually interfere with operation of the legitimate NPOs, because it might be counterproductive once funding flows are restricted and interference of legitimate operations of NPOs take course. What NPOs are likely to dive into is looking at the unregulated channels, and this would be very dangerous to any country in the world. So there is need to balance between security and countering terrorism financing in the NPOs. The other we are seeing is the grey list induced panic. The grey list induced panic is creating some level of unintended consequences. Some of the laws that are being enacted do not follow a due process. There is no clear consultation, and sometimes the implementation becomes a challenge. On this very platform, the Leaders Talk Africa, I think we hosted a talk on beneficial ownership, and there were conflicting messages on implementing laws on beneficial ownership. Participants on the platform were wondering either NPOs are beneficial owner or not. Other countries enforce these particular laws. Other countries will tell you that no, NPOs are basically humanitarians, they are not beneficial owners. And this is a product of the grey list induced panic. And I think there is need to create awareness on the implications of laws that do not follow due process of clear consultation. I remember in Uganda, one of the events that happened, there is when Parliament passed almost close to 9 major amendments of different laws within one day. And the sector was not consulted, but yet these laws had implications on the sector. The other we are looking at is the regulatory burden. My brother Emil has responded to it, and Molken. But again, in Uganda, we still have that regulatory constructs that subjects the NGOs on heavy compliance burden. You have to comply with different regulators, file returns with different regulators. Some attract money, some do not, but all in the name of having an oversight on the roles and the regulation of the NPO sector. This is still work in progress. I think it's one of the things that perhaps we shall be pushing back against over-regulation. And this can also be solved by a simple thing like automation, where data is put together and NGOs do not have to go into this carrying of heavy files to different regulators. The other is there is an element of mistrust and suspicion among the NPOs and different regulators. In 2025, we ran a survey on measuring trust between the regulators and the regulated, and one of the aspects was on the relationship between the NGOs and the Financial Intelligence Authority and the regulator. But all the data was revealing some level of mistrust, intrusiveness, selective enforcement of some of the regulations related to protecting NGOs from TF abuse in line with their operation. So these are some of the things that perhaps, again, there is need for robust cultivation of trust between the regulators and the regulated. But overall, again, just like Monshid mentioned about the horizontal review report, which was a comprehensive report, the measurement of the landscape on the implementation of Recommendation 8 is not yet up to date. Actually, the report reveals that only 19% of the SMLAG countries within the region are largely compliant. The rest are either non-compliant or partially compliant. And that's where Uganda is. Uganda is partially compliant. But one of the milestones we are seeing is Uganda is carrying out again another risk assessment for TF to update its report. And I think compilation of the report is in the final stages. Soon we should be having a TF risk assessment report. And I think we shall use it as a mirror to see where we are, what needs to be done, and what more can we do together as a sector, but with also the law enforcement agencies. In line with Recommendation 8, what do we need to see happen as the sector? And Hilda asked that some of the countries are doing what is called self-regulation. Uganda is one of the countries that has a structured self-regulatory framework called the QAM, Quality Assurance Mechanism, which actually advocates, builds capacity of the NPO sector to have robust mechanisms of governance and policies to mitigate some of the abuses like for TF. However, some work needs to be done. NGOs, in order to have evidence of credibility when it comes to self-regulations, needs to demonstrate a shift from what I call a shift from policy shelving to policy implementation. The QAM advocates for a minimum standard that NPO must operate, minimum policy guidelines that NPOs must have. But it's one thing to have these guidelines and you keep them in the shelves. You have a financial manual, very good. You have a fundraising manual and policy, very good. You have some tools in place, but these are on the shelf. So we should move a step higher to say, okay, what does the policy say? What do we implement? If you have a policy that you have to do a background check on your donors, on your employees, what do you do? Do you actually implement them? I think if we demonstrate policy implementation, the quality assurance mechanism enforcement, it will be evidence enough, actually, to prove that, yes, the sector is credible and is committed to jointly fighting these vices. The other is we need to build the capacity on trust in compliance. Because of the mistrust and suspicion that exists in some of the countries, including Uganda, any policy that comes from the regulator, any policy that comes from the government is sometimes received with a lot of mistrust and suspicion. So there is a need to bridge the knowledge gap that, yes, it's good to run a well-regulated sector, which is the NGO sector, but it's not good to over-restrict it. We are doing this not only for the good of the sector, but also for the good of the country. And through platforms of engagement, meaningful engagement, trust shall be built over time. In terms of the high-level convening, this is, again, one wonderful product of the Civic Advisory Hub. We thought that it would be good to create platforms of engagement, platforms of learning, platforms for advocacy when it comes to the implementation and enforcement of the FATF regulations, beyond even Recommendation 8, because there are some other regulations that either directly or indirectly interfere or interrupt the operation of the NPO. We've listed some of them. Recommendation 24-25 on beneficial ownership is one of the aspects that we are looking at. What should we expect in this high-level engagement? Again, drawing from the prior engagements, one that took place in 2024 in Uganda, that mainly focused on implementing anti-money laundering and counterterrorism financing while safeguarding civic space, had really very good outputs that informed the Botswana 2025 high-level engagement. The Botswana 2025, we basically looked at placing civic space at the heart of countering the financing of money laundering and terrorism financing. Civic space became a subject matter, and key highlights that came out, we produced what we call a policy paper, which we shared with SMLab and GIABA with 9 areas of recommendations. And one of them was to strengthen collaboration in combating MLCFT with civil society sector, not as basically key implementers of this recommendation, but also as subject matter experts. So we want to formalize these engagements that we are able to meet with different regulators within our jurisdiction. So we expect to have several master classes, and there is one, like been highlighted by Emil, that is going to be organized and conducted by SMLab and GIABA. We are still talking to GABAC also to join us in this particular engagement, and we create awareness of law enforcement agencies, Financial Intelligence Authority, bankers in implementing the recommendation 8 to the standard. The theme is quite catchy. It basically focuses on recommendation 8, implementing FATF recommendations correctly in Africa, practices, challenges, and opportunities. Our our co-lead convener, Spaces for Change, is equally also ready to support on any engagement. Should you have any masterclass that you'd so wish, please, you can put it in the chat portal, and we are happy to carry it out as one of the key questions. So expect to meet subject matter experts from across Africa. We have several regulators that are coming, regulators of the NPOs, financial intelligence authorities from across Africa. And it's a learning platform, a networking platform, and also to continue the conversation. Thank you, and over to you, Hilda.
Thank you very much, Yona. Thank you for giving us the NGO perspective, because apart from the FSRBs, it was only just right to get the NGO perspective. And the fact that we get to realize, yes, that there is progress on implementation of Recommendation 8 with clear examples of stuff like Uganda, NPOs being delisted from the list of accountable persons, which was done last year. It was a success and a plus for the country. Thank you for highlighting the several initiatives that we need to put in place to also cultivate trust with the regulators, having dialogue platforms, conducting outreach, conducting compliance outreaches as well for people to appreciate what compliance is, but also to identify the gaps that we have in the legal framework and advocate for them to be amended. The highlight on the high-level engagement, thank you very much. And it will be a hybrid. So for those of us who will not be able to make it to Nigeria and Abuja, we'll share with you the links through our communication channels, and you'll be able to follow, except for the master classes. I'll take this opportunity now to open this up to the floor. Should you have any question, kindly raise up your hand. If you feel like you don't want to talk, please type your question in the Q&A or in the chat, and we'll read it out to the panelists to respond to them. And I'll move right away in the Q&A section. How from Anne Brown? Anne Brown is from South Africa. She stepped out. How are other countries implementing sanctions for non-compliance? South Africa is in the process of amending the NPO Act, Section 20 and 30. That applies to NPOs required to register. The Act currently is voluntary registration. The required to register applies to those working outside of funding projects beyond the borders. The penalty started in the amendment bill for non-compliance is a recommendation 1. It ran 1.5 million or 5 years imprisonment. Your thoughts on that? And then from Deng Philp is from South Sudan. He works with the Financial Intelligence Unit of South Sudan. Many countries face challenges in engaging community-based organizations operating at the grassroots level during the NPO terrorist financing risk assessment. In many countries, these organizations operate informally without registration or formal regulatory oversight. This may limit their visibility to authorities and potentially increase their vulnerability to terrorist financing abuse. Have any of your jurisdictions encountered the existence of such informal CBOs? If so, what approaches have been adopted to identify, engage, and incorporate them into the NPO risk assessment process? And what lessons have been learned from efforts to reach and involve them in the implementation of FATF Recommendation 8? And then we also have one from Ivan Agaba. How about the profit-making organizations? Kindly give us context by the case of Lafarge Group funding the activities of ISIS in Syria and the Sahel. One last one from Manuel Nicholas. May the presenter help share with us some of the evidence-based approaches to NPO risk assessment? Do we have some hands raised? Yes. Okay, we'll get can the panelists respond to the questions that have been raised, and then we'll get to the next set of questions and for people who have raised their hands.
Oh, okay. Maybe let me start, and my colleague panelists can come in as well. I would start from the issue raised with regards to community-based organizations operating at grassroots levels, and how this, because of the informal nature, cannot be captured during risk assessments and all that. Now, let me quickly say that, yeah, this is a common phenomenon that you usually encounter during risk assessments, and indeed, even within the Java region, we have some of these occurrences. A significant number of community-based organizations, faith-based community initiative, youth associations, and all that operate informally and may not be registered with relevant authorities. But while many of these organizations perform legitimate and valuable social functions, their informal nature often means that they fall outside the traditional regulatory and supervisory frameworks, making them more difficult to identify, assess, and engage during NPO risk assessment. But in practice, a number of our member states have adopted some approaches in order to ensure that they are captured. Let me quickly highlight 3 approaches. One, countries have increasingly relied on local level stakeholder engagement rather than solely on the central government database. And in my statement, and indeed in all the speakers' statements, we talked about extensive engagement with the NPO sector themselves during the risk assessment process. And so you don't need to rely only on the central government database, but you need to have a lot of local level stakeholder engagement. And these usually include working with local government authorities, traditional leaders, religious leaders, district assemblies, municipal authorities, community development officers. In most of our jurisdiction, we have social welfare departments. You see them across the spectrum of the local government structure. Umbrella civil society networks are also part of some of the institutions that you would have to engage to ensure you have a better visibility of the NPOs. Now, two, some member states have also incorporated consultations and regional workshops into their NPO risk assessment process, in that rather than consulting only the registered national NGOs, the assessment teams, which usually you see groups are formed. For example, the NPO, the group working on the NPO sector, do conduct some level of engagement, outreach activities together with the NPO regulator at the regional district levels to better understand the landscape of informal organizations operating in these environments. So through these engagements, capacity building by the NPO regulator and sometimes by the group that is championing the NPO risk assessment, you will be able to solicit some of these information. The third one has to the third one largely is on leveraging information from multiple sources. I think we've mentioned the triangulation. So social welfare department, charity regulators, local administrations, donor organizations, faith-based networks, humanitarian coordination platforms. In most of our jurisdictions, you have the NPO themselves having their own coalitions, their own working groups and all that. And if you engage them properly, you'll be able to have a better picture of some of the NPOs that may be operating at the community level, at the district level, but not necessarily registered at the national registry. So with these three approaches, it's possible for you to be able to have a better overview of how NPOs are operating both at the informal sector and formal sector. And it is important that you factor all these elements into the risk assessment. Now, talking about lessons learned, one of the key lessons learned is that registration status alone should not determine whether an NPO should be considered in the risk assessment process. The fact that you are not registered doesn't mean that you are out of scope. No. The primary objective is to understand the nature of activities being undertaken and the communities being served, sources of funding and all that, the vulnerabilities and stuff, and factor it into the assessment. Another important lesson is also about building trust, as Yona rightly said. Now, what we've noticed is that where authorities approach informal community-based organizations primarily from an enforcement perspective, then participation tends to be limited. They will not want to come up. They will not want to collaborate. They will not want to engage. However, if that engagement is framed in a form of collaborative effort to build understanding, for us to work together to appreciate the risk dynamics in order to protect the sector from abuse, then you get more of such institutions or more of such community-based organizations willing to partner and share information with you. So the key point is that risk assessment of NPO sector should not only be on the registered ones, but even the informal ones are important. Sometimes they may even pose the greater risk to you. So these are some of the three levels of engagement that can be deployed to ensure you are covering this sector. Now, let me also talk about the question that has to do with, I think it's about evidence-based approaches to NPO risk assessment. And this is also equally important because, as we've said, the NPO risk assessment should be one that relies on data, actual data, verified data, intelligence, typology, case studies, and all that. It is not a hearsay. It is not theoretical. It should not be assumptions. It should be based on facts and evidence. And what are the practical ways to do it? As we've highlighted, first, it must start from sector mapping and segmentation, because FATF itself acknowledges that not all NPOs fall within the FATF definition of NPOs. And the only way to achieve this is to ensure that you are mapping the entire NPO sector, you are categorizing the NPOs by the various activities, by their operating models, distinguishing them, and understanding how they operate so that you will be able to determine the ones that fall within the FATF definition. Then there is also a need to do your trust-based assessment. Now, what are the actual evidence of terrorist financing abuse involving these NPOs? And we've mentioned that you will get some of this information from the TF investigations and prosecutions. In most cases, you see countries say they've not had any TF investigation and prosecution. Now, what about FIU intelligence? What about STRs related to NPOs? What about the typology reports? What about law enforcement intelligence? It may not be prosecuted, but they may have that intelligence. What of the regional and international case studies? So the important thing is you need to answer the questions as to whether NPOs have been abused for TF purposes in the country, the types of NPOs that were involved, what methods were used, what are the geographic areas that have been affected. Now, once you do those stress assessments, then you also conduct your vulnerability assessment. All these are inbuilt, most often in the tools that you use. Vulnerability assessment, you want to see the geographic location. Usually NPOs that are located in conflict zones, border areas, or areas affected by violent extremism are NPOs that you need to look at critically. What are the financial vulnerability, heavy reliance on cash, significant foreign funding, complex cross-border transactions, governance vulnerabilities, weak internal controls, poor record keeping, limited board oversight, delivery of humanitarian assistance in inaccessible areas, use of intermediaries and partners. All these are practical indicators that you need to factor into the risk assessment process. And remember, it can only be done best when you engage in broader consultation, even with the NPO sector themselves. There is no better person who understands the NPO environment than the players themselves. And that is why we always say that it is important you see them as partners in the entire process, in terms of having access to information and data, in terms of having a better understanding of the entire sector, so that you'll be able to take the appropriate measures working together with these NPOs. At the end of the day, all manner of approaches that would help you to be able to use evidence, that will help you to be able to use data, that will help you to be able to ensure that whatever you are doing is based on facts and not hearsays. Whatever you are doing is based on evidence and not assumptions. It's important you do that to ensure that you are actually conducting a data or evidence-based risk assessment to inform your decisions. Maybe let me pause here so that if Molekin also would add some responses. Thank you.
Raj, Emil, for that exhaustive response. Mulkin.
Yes. Yeah, I think Emil has really simplified my job. Regarding the first question on sanctions, according to the FATF Recommendation 8, sanctions for NPO non-compliance should be effective, proportionate, and dissuasive. Now, based on the question raised, especially 1 million rand or 5 years imprisonment for non-compliance, whether it is appropriate sanction or not, I think we need to look at it from a proportionality point of view, because there is a sanction to be imposed based on the nature of the violation, whether the intent or negligence was involved, whether terrorist financing risk is present, and whether less severe corrective measures are also available before criminal sanctions are imposed, and so on. In doing so, we can keep the proportionality of the sanction. So our advice to our colleague from South Africa is maybe in terms of amending. I know, Hilda, you told me that she's not around, but if you could also convey our message that this line of sanction may not be in line with the standard, especially when it comes to the issue of proportionality. The second point that I would like to raise is also sanctions should not be the first resort. They should be last resorts. What does that mean? There are step-by-step processes that regulatory authorities normally follow before they are imposing such kind of sanction. I can mention, for example, some best practices in countries like Netherlands, whereby even before they are putting any kind of sanction in their law, they do a normal, a regular consultative dialogue to make sure that the NPOs are also part of the process. They will have a sense of ownership. And then once they are in agreement with the rules of the sanction and so on, now the authorities will start imposing for any non-compliance behavior, depending on the degree or the level of the violence. I can mention examples like United Kingdom, whereby you see the Charity Commission for England and Wales. They follow step by step. They have first advisory notices, followed by compliance directions, action plans, suspension, removal of the trustees. They also have freezing power, civil enforcement, deregistration, and if necessary, if any NPO is found to be involved in crimes like terrorism financing or terrorism or any other financial crime, they have also criminal sanction. When it comes to our region, participants may wish to note that out of our 22 member countries, Ethiopia, Mauritius, Botswana, and Namibia are having a good rating on recommendation 8 on LEC. So the way how these countries have set the laws on sanction and how they are enforcing might be something that could be taken as a good experience in our region. Now, going to the second question about the community-based organizations, there are different options which countries normally need to use. Like my brother Emil said, it is common in Africa, Asia, and the parts of the Middle East. If we look at the mutual evaluation report of the countries in this part of the world, you may see that the community-based organization issues are almost the same. It's across the board. So these are the best practices from the reading of different mutual evaluation reports. The first one is, having engagement with local government structures is important. For example, if you look at the different mutual evaluation reports, several countries have relied on district administrations, municipal councils, ward community development officers, local security communities, social welfare offices to identify informal groups operating within the community. And this has proven effective because local authorities often possess practical knowledge of grassroots organizations that are not captured in national registries. The second available option is to have a proper engagement through umbrella networks and phase structures. Normally, if countries could encourage the community-based organizations to gather themselves in terms of establishing umbrella organization or consortium, like phase councils, NGO forums, humanitarian networks, women, youth association, umbrella CSO coalitions, they can help indirectly at least to reach unregistered or informal groups like community-based organizations. The third option for our member countries or for the countries in Africa to consider is in terms of applying risk-based outreach rather than immediate enforcement. For example, countries with good practice, they normally avoid beginning with sanctions or compulsory registrations, like I said before. Instead, they focus on awareness raising, voluntary engagement, simplified guidance, and financial integrity education. All this can help, especially in areas like which are having fragility or conflict, conflict nature, and where informal community-based organizations provide essential humanitarian and social services. This method may help for you to identify the different community-based organizations. The fourth option that I have observed from the different mutual evaluation is normally countries, they do, surveys or community consultations. Regulatory authorities, they develop a simplified questionnaire using a simple language, and they distribute it throughout to the community using their local languages, and they can get some responses because they have used different simple languages, also the local language. And you can also have a holding of community dialogue. sometimes this helps because some of the community-based organization founders and so on, they may not be even literate. So by having a community dialogue and so on, they may help you to know which ones are community-based organizations without necessarily having a formal registration on them. And the last option is some countries we have observed that they are also adding the informal actors in their national risk assessments so that they get at least qualitative information, albeit it may not be quantitative information. And all these are aligned with the FATF standards because registration, by the way, is not a requirement. But registration is a good practice when it comes to high-risk NPOs for terrorism financing. Thank you.
Thank you very much, Moken. We're running out of time. Just for the participants on the call, kindly just give us 10 more minutes. I don't know if there's any participant that has a burning question. Please, if you have a burning question, just one, raise up your hand and raise the question. So we have one in the chat. The situation is even made by Benson Ekwe Ochen. The situation is even made worse by linking the work of NPOs as a threat to national sovereignty, as implied in the recently passed National Sovereignty Act 2026, which puts a cap on funding and expanded reporting and registration requirements. This definitely shrinks civic space further. So what can be done to improve the situation of NPOs in Uganda? That's the only question that we have. There's one in the chat room, which I also in the Q&A by Paul Melinda. Proportionality is a strong element of Recommendation 8. However, the interpretation and implementation of what is proportional seems to be determined and viewed differently. The NPOs, for example, in Uganda are feeling the weight of burdensome requirements with multiple reporting centers. Although there are efforts to dialogue, the burden is still heavy on NPOs. Garang from South Sudan, why should NPOs go to FIUs and carry heavy files, and what mechanisms should we use to avoid that, especially in South Sudan? This is the last question. This question is on the issue of burden of over-regulations of NPOs as unintended consequences of Recommendation 8, as mentioned by Mr. Wanjala. How can authorities such as FIUs help to ease, or do you have experiences from Uganda on how the Financial Intelligence Authority has helped ease this challenge to ensure that NPOs continue to operate unhindered, or are there steps to ensure there is a balance between compliance and need for NPOs to operate, for instance, in the case of emergencies here in South Sudan? Those are the last questions. We have one from this is the last. I couldn't leave it out, Bill. She's a friend from Trinidad and Tobago, from Kerry Thomas, who works with the FIU in Trinidad and Tobago. What are the most common unintended consequences that NPOs continue to face in practice? For example, banking access, delays in funding, and increased compliance costs. In 3 minutes from the panelists, kindly respond to this, and then you give us also your final remarks in 3 to 4 minutes. Thank you.
Maybe let me start, and my brother Emil can come in also. I think there are so many questions now raised, but generally, what I should say is, first of all, NPOs are not reporting institutions. I know in some jurisdictions, like Namibia, Ethiopia, and so on, the FIUs themselves are the regulatory authorities of the NPOs. In that regard, NPOs are not necessarily reporting institutions, but they are treated to be one of the regulated entities by FIUs, especially when it comes to the issue of terrorism financing or terrorism matters. If FIUs are not the designated regulatory authorities to oversight the operations or activities of NPOs in a given jurisdiction, our advice is, unless they may be serving as informants or whistleblowers when they see any illegal or criminal activity. They should be discouraged in approaching the FIU to serve as a reporting institution like bank or the NFBs. And like I said before, when it comes to the issue of proportionality, the range of sanctions, they should be there. But if the sanctions are still persistent and are not proportionate after having a dialogue or something, this is now a matter to be considered as unintended consequence, especially when there is over-regulation or when there is a disproportionate sanction against any of non-compliance behavior towards the legal requirement of any NPO. So my idea for you is first have engagement, have a consultative dialogue, a proper dialogue. But if the countries are not amenable to accommodate the issues that you are raising, there is still a way now in the universal procedure to escalate the matter to a SAMLAC, for example. A SAMLAC can look at the situation, and if there is a prima facie evidence for a SAMLAC to consider, there is always a way or a possibility to engage with any jurisdiction, any member jurisdiction. But at the same time, participants, especially participants from NPOs, should note that when countries are having different laws and so on and so on, as far as those laws are not concerning, counterterrorism financing issues and so on and so on, we cannot involve in the sovereignty of jurisdictions, unfortunately. So you may use the other avenues to deal with those matters, because we normally observe that some of the issues that NPOs are raising, they may not necessarily be considered as unintended consequences. Though in their view, they may consider them as overregulation or unintended consequences. SAMLAG, the global network, only deals with matters towards the countering terrorism financing or terrorism issues. Other than those issues, unfortunately, we don't have a mandate to deal with any concern to be raised by NPOs. I think maybe let me stop here because of time, and if my colleague Emil would like to add, he can add. Thank you.
Yeah, thank you, Molekin. Let me just quickly add some few responses about NPOs going to the FIU carrying heavy file. I don't know for what purpose, but as you rightly said, in most jurisdictions, in an attempt to monitor the space, this function is being handled by FIUs. Some jurisdictions, what they do is that the FIU stands in until an appropriate regulator is established, and then that responsibility shifts to them so that the FIU focus on their core mandate under the FATF recommendation. However, in all these circumstances, as we said, all regulatory measures should not be in a position to frustrate NPO activities. Yes, there may be some reporting requirements, but even then, this should be informed by the risk assessment so that it is varied in accordance with the levels of risk exposure or vulnerability these NPOs pose. When it comes to proportionality, yes, proportionality is key, and which means that range of sanctions must be applicable, because the non-compliance are of varied degrees and of impact. So one size does not fit all. Now, that is so what JABA advises is that our member states, in designing their laws, in designing their regulations, in designing their sanctions regime, there should be broad consultation, involve the NPOs themselves. Sometimes one of the parties may raise the issue of disproportionality just because they don't appreciate the rationale and the import of that sanctions. So it is important you have that broad engagement in designing these sanctions so that even from the word go, everybody understands their obligations and everybody understands the sanctions regime applicable. And in this process, where any of these sanctions may amount to disproportionate application, you'll be able to address it at the drafting stage of these regulations and laws. Now, but where it is established that the sanction becomes disproportionate, as said by Molekin, it becomes an area where the unintended consequences process can be activated. And where it is established that indeed that has happened, then measures will be taken by the Secretariat in order to ensure that the country abides by the set processes. What else? Let me see. There was this issue of linking the work of NPOs to threat to national sovereignty. So this is more of a nexus between national security implications and ensuring that the sector is also not abused. As we said, there must be a balance. Human rights issues, a balance not to frustrate the efforts of the NPOs. We must all acknowledge the fact that NPOs perform functions that central governments sometimes are unable to perform. And indeed, in these conflict areas and conflict zones, the NPOs are ready to sacrifice and go there and provide these social interventions. So that is why we must ensure we have a good balance. And as we said, all again emanate from an understanding of the NPO sector via the risk assessment to know where they are operating in terms of the geographical risks and all that. And the ones that pose significant vulnerability to national security, then a targeted measure would be put in place to ensure that they are operating within the confines of set regulations or laws. But outside that, it is important we don't classify the entire NPO sector as a threat to national security. I've had conversation where a country wants to shift the regulation of NPOs to the national security architecture because they think that they are exposing a lot of risks. And I said, no, you cannot do that. It is not all NPOs that creates that kind of threat or vulnerability for you to say national security should take charge of their monitoring. That would amount seriously to an unintended consequence because we know what comes with it when national security is moving into such spaces. So that understanding must be there. I think I will conclude by saying that gone were the days where jurisdictions will conduct NPO risk assessment without engagement or with limited engagement. As we said earlier, some NPOs are even operating in the informal sector. One of the challenges we've identified with some of the NPO risk assessment was that when they were conducting, because there was no broad consultation, they left out the informal sector, or they left out NPOs, community-based NPOs and all that, because they focused on only the registered ones. So the major lesson is that there should not be an NPO risk assessment without consultation with the sector players themselves. In fact, there should be an integral part of the risk assessment process. When it comes to development of laws, regulations, the players must be deeply involved in the process. If they are deeply involved in the process, they understand the reason why certain measures are taken, the rationale, and it creates the conducive environment for them to abide by these regulations. You should not just establish or set up a regulation and dump it on them. No, they should be seen as partners to development. They are strategic partners that must be involved in the entire spectrum of all activities you are undertaking to ensure the sector is kept in conformity with the FATF Recommendation 8. I think because of time, I will pause here as well. Thank you.
Thank you very much, Emil. And I'll start from you. In 1 minute, give us just your parting remarks in just 1 minute.
I will reiterate the point that the JABA Secretariat sees the NPOs as significant partners to socioeconomic development, And for that matter, we will continue to work with our member states to ensure that in implementing the FATF Recommendation 8, issues of human rights, issues of unintended consequences are well addressed to ensure there is a conducive environment for these NPOs to thrive. And at the end of the day, collaboration, collective effort towards ensuring implementation of FATF Recommendation 8 is key, and this would also put in all the value chain, the assessments, capacity building, technical assistance, so that at the end of the day, our member states are assisted to appropriately deliver and implement effectively the requirements and obligations under recommendation. We stand ready to support all member states in this sphere. Thank you so much.
Thank you very much, Anil. Over to you, Mulken. Any parting remarks in 1 minute?
Yes, dear participants, like we said before, the revised Recommendation 8 framework is now offering us an opportunity to move beyond outdated assumptions and towards smarter and more effective approaches. Protecting the NPO from terrorist financing abuse is important. Protecting the ability of legitimate organizations to operate freely and deliver assistance is also equally important. These objectives are not contradictory in our view. Rather, they reinforce one another. Assembly agreements committed to supporting member countries in implementing risk-based and proportionate measures that are consistent with the FATF and other international standards and respectful of fundamental freedoms. We also remain committed to ensuring that our mutual evaluations, our activities towards the proper oversight and regulation of NPOs reflect practical realities, credible evidence, and balanced judgment. Thank you.
Thank you very much, Mulken. And over to you, Yona. Any parting remarks and closing remarks
Great.
for this webinar?
Parting remarks. One.
And closing remarks.
Okay. Parting remarks and closing remarks. Thank you, Hilda. I should say my parting remarks is that we should continue to strengthen the oversight and accountability on the implementation of Recommendation 8 across the continent as a whole. It should be a right and a responsibility for all civil society actors. I should also respond to one of the questions highlighted by Benson Ekwe about the Protection of Sovereignty Bill. This law presents a different regime of the MLCFT regime. What I advise perhaps members of the civil society, but also in other countries where foreign agent laws have been passed, to do an assessment on reimagining the risk. What risk does this present and how best can you engage? Lastly, one of our key principles as Civic Advisory Hub is what we call the civic space diplomacy. Civic space diplomacy demands that we should engage with the regulators. We should engage with those we feel we would want or wish to influence. So just like Emil has stated and Molken, there is need for more dialogue spaces that can help us capacitate, that can help us participate, and that can help us influence reforms. Please, members of the civil society, do not wait when such engagements present themselves. Do not wait to be invited. Actually invite yourself to such engagement. With closing remarks, I should say thank you, our moderator, Ms. Hilda, for taking us through this very captivating webinar. To my fellow panelists, my brother Molken, thank you so much. And we are happy that we always associate and knock the doors of SMLAG, and you're ready to help, you are ready to support in any way, both at the accounts, but also now with the Leaders Talk Africa. Again, my brother Emil, thank you so much. That You've been able to share insights from the regions of West Africa, very good examples to all of you, and to our listeners who have taken their virtual seats. We cannot actually appreciate you enough, but thank you for being part of the engagement, contributing to the engagement by asking very key strategic questions. We are going to compile these questions and document a profile for this particular webinar and share it. But also for some of the people who might have missed, all our engagements are going to be, we are going to post you a link for the YouTube for you to further review the intervention by these very good subject matter experts, heavily informed. I would not want to conclude without saying we are ready for Abuja. For those ones who have not registered, kindly register. Feel free to sponsor yourself to Abuja. It is July from the 14th to the 17th, where again you are going to interact on different subject matter experts, with different subject matter experts and on different topics in line with Recommendation 8 implementation. We remain your very key and lead experts on this agenda in the NPO sector, the Civic Advisory Hub. Thank you, and over to you. I declare the engagement officially closed. Thank you, Hilda.
Thank you very much. I request the panelists to stay on and we take a group photo. Thank you very much to all the participants. Thank you very much, Yona. Thank you very much, Emil. Thank you very much, Mulken. And thank you very much to the CAR team for bringing this to what it was. It was a very fruitful conversation, and I can attest to that with the remarks that are coming in from the chat room. Everyone is testifying that it's been a very insightful engagement and very impactful discussion. Thank you very much. Panelists, please put on your camera so that we take a group photo. To the participants, till we meet again next month on the next TLT Africa. And should you have a very biting topic that you'd want us to discuss on this platform, please write to us, go on our website and write to ask@civicadvisoryhub.org. Should you have a subject matter expert on the continent or across the globe that you'd want us to feature on this talk to the Leaders Talk Africa, please go on our website and write to us. We'll definitely respond. Thank you. Bye.
I was part of a recent survey by the EUC, and it shows that 67% of civil society organizations across 60 countries have been directly affected by the USAID funding decision.
We are living a time of uncertainty as a non-profit sector, and some of our organizations are actually facing existential threats.
I think it's actually a huge opportunity moment for the localization agenda, however we want to frame it.
NGOs, the churches and other NPOs should be removed from this list. But also it is pushing the country to now adopt a risk-based approach in targeting only high-risk NPOs in accordance to the FATF definition.
The FATF, which is the global body that sets standards for countries with respect to combating money laundering, financing of terrorism.
I don't think that being delisted means that it's time to get into a relaxed mode. No, that's not what it means.
Today we are blessed and honored to have the fine brains on the African continent.
Human resources are exploited along the way. Financial resources, of course, are exploited along the way.
We have this incredible wealth, yet for some reason we also have some of the highest poverty statistics.
This is an international discourse, so it's a tripartite, not even a tripartite, but actually continental.
On behalf of the Civic Advisory Hub, I take the singular honor of welcoming you to this edition of the Leaders Talk.